Welcome to the 30 Years, 30 Cases video podcast series, a series launched by ERA, the Academy of European Law in Trier, to mark its 30-year anniversary with a presentation of landmark cases of the Court of Justice of the European Union. My name is Karolina Rokicka, and I'm an ERA lawyer responsible for institutional topics. Today, we will discuss a famous judgment in case C-64/16, Associação Sindical dos Juízes Portugueses, delivered back on the 27th of February 2018. The case concerned the salary reduction measures, which the Association of Judges acting on behalf of the Portuguese Court of Auditors decided to challenge. They argued that these measures would infringe the principle of judicial independence. This landmark case is, in fact, about the interpretation of the fundamental value of the European Union, that is the principle of the rule of law. What was so special about this judgment, which some describe as arguably the most important judgment since Levert, and what impact it had on subsequent case law concerning the rule of law, will be explained by Mr. Stanislas Adam, legal secretary at the Court of Justice of the European Union and professor of European Union law at Ghent University. Mr. Adam, welcome to the podcast, and thank you for joining us today. Let us start with the facts of the case. What exactly was this case about?
Thanks, Carolina. The case has to be understood in the aftermath of the financial crisis in 2008. Portugal was placed under excessive deficit procedure and had to adopt measures to restore balance in public expenditure, including in accordance with EU measures, EU rules. And it is in that context that Portugal adopted a law in 2014, introducing salary reductions applicable to most employees in the public sector, not only judges, but also political appointees and public servants in general. The reductions were proportionate to the level of income of the employees concerned. And the trade union of Portuguese judges challenged before the Supreme Administrative Court of Portugal measures implementing that law as applied to members of the Court of Auditors of Portugal, the Tribunal de Contas. They challenged it indeed, as you mentioned in your introduction, claiming that such salary reductions would undermine their judicial independence. They took the view that it was therefore incompatible with Portuguese constitutional law, but also with two provisions of EU law on which we will come back, namely on the one hand, Article 19, paragraph 1, more precisely the second subparagraph of Article 19, paragraph 1 of the TEU, and Article 47 of the Charter of Fundamental Rights of the European Union, the principle of or the right to an effective remedy and to a fair trial. The case did not concern implementation of EU law by a member state, which explains why the referring court, the Supreme Administrative Court, decided to focus its reference on Article 19, because Article 19 requires the member states, I quote, to provide remedies sufficient to ensure effective legal protection in the fields covered by union law. Thus, unlike Article 47 of the Charter, which only applies when the member states implement EU law, on the face of it, Article 19 does not seem to require implementation of EU law in the case at hand. which explains this why the referring court focused on the TEU, Article 19 of the TEU.
Thank you. In this case, the opinion of the Advocate General was issued, but the Court of Justice did not follow it. Could you please explain us the approach that the court took?
Sure. In order to understand the difference, one has to remind the wording of Article 19, paragraph 1, second subparagraph, which, unlike Article 47 of the Charter, makes no reference whatsoever to judicial independence. As you know, conversely, Article 47 makes a clear distinction between, but covers both, the right to an effective remedy and the right to a fair trial, access to a court established by law and acting in an impartial and independent way. And the Advocate General based his analysis essentially on that difference in wording between the two provisions, arguing that it was not by chance that the wording was different between the two provisions. In the AG's view, that difference meant, in essence, that the second subparagraph of Article 19, paragraph 1, TEU, concerns exclusively the setting up of a system of courts capable of offering effective judicial protection in the fields covered by EU law. Judicial review of compliance by the member states with EU law is to be ensured by the court, that is the first subparagraph of Article 19, paragraph 1, acting in cooperation with national courts as courts of EU law, assisting the court in that task of verifying compliance by the member states with EU law. That provision, in the AG's view, would thus be of a procedural nature, in essence, and therefore not cover all the guarantees contained in Article 47 of the Charter, which, as I said in the introduction, applies only when the member states, or in cases involving implementation by the member states of EU law. And the court indeed took a completely different approach. The court recognized, on the contrary, a direct link between the principle of effective legal protection in Article 19, paragraph 1, and the right to an effective remedy and to a fair trial as guaranteed by Article 47 of the Charter. The court, in other words, did not consider it decisive that Article 19, paragraph 1, second subparagraph, does not refer expressly to judicial independence. And that finding, that essential finding, is based on essentially two pillars, I would say. First, the union, said the court, is based on the value of the rule of law, which is enshrined in Article 2 TEU, which means that individuals, litigants, should be able to challenge before independent courts the legality of any measure relating to the application to them of EU law. And the court adds that Article 19, it is a first connection that the court makes, Article 19, paragraph 1, gives concrete expression to that value of the rule of law, because the very existence of effective judicial review designed to ensure compliance with EU law is, and I quote the court here, of the essence of the rule of law. Second, the court emphasized that judicial independence is inherent in the task of judicial adjudication. In other words, effective judicial protection, unlike the position adopted by the Advocate General, cannot be decoupled from the right to an effective remedy. It forms an integral part of the right to an effective remedy. And interestingly, the court here used case law concerning Article 267 of the TFEU, that is the procedure for a preliminary reference to the court, the preliminary ruling mechanism. the court referred to case law under which it is clear that only independent courts may activate cooperation with the court through a reference for a preliminary ruling for various reasons. That shows, in the court's view, that in the system of remedies conceived of by the treaties, only independent courts can or are able to ensure effective legal protection within the meaning of, or as a general principle of EU law, and within the meaning of Article 19, paragraph 1, second subparagraph. So it is those two links that characterize the court's reasoning in Juízes Portugueses, and which makes that case so important.
Exactly. This judgment became, in fact, a reference point for the cases concerning the rule of law that followed. I was wondering if you could tell us why this judgment gained such an importance. So if you could summarize it once again, just for us to keep that in mind.
Yes, thank you, Carolina. There are two essential lessons to be drawn from that case. The first concerns the scope of application of Article 19. That scope is, and the court makes it explicit in the reasoning, broader than that of Article 47, because Article 19 and all the requirements, therefore, of Article 47, which, as I said, Article 19 captures or covers, apply in all instances where national courts have jurisdiction to adjudicate cases involving interpretation or application of EU law. That is very horizontal, very general. In other words, those guarantees do not or are not limited to situations where, or cases where, member state implements EU law, such as cases involving VAT or cases involving protection of pregnant women under relevant directives and so on and so forth. It is much broader than that. And the case of Juízes Portugueses illustrates that, because that case was not specifically a case concerning implementation of an EU measure. Okay, there were a number of EU law measures that explained why Portugal had adopted that law, but it was not those measures as such that were at issue and even applied by the Supreme Administrative Court in the main proceedings. So that is a first aspect, that very broad scope of Article 19.1. The second, even more important, of course, concerns that link, which I emphasized, between the requirement in the second subparagraph of Article 19.1 and, on one hand, the rule of law value in Article 2 and substantive guarantees of the right to an effective remedy and the right to a fair trial under Article 47. What makes it so important is that that reasoning, that link, basically means that the rule of law value becomes judicially cognizable in EU law, before EU courts and before national courts, by the way. At least to the extent that it covers the right to an effective remedy before independent and impartial courts. I make a short comment here. Of course, the rule of law value is a broader concept, is a broader value, but an important aspect of it is, of course, the right to an effective remedy before a court established by law and acting independently and impartially. And that is judicially cognizable thanks to, I would say, the judgment in Juízes Portugueses.
Mr. Adam, could you illustrate the relevance of this judgment for the subsequent case law?
Sure, Carolina, thank you. That judgment formed the conceptual basis for important developments in subsequent case law. And the reason for that is that judicial cognizability of the rule of law value that I just mentioned. It allowed the court either in the context of references for preliminary rulings or in infringement actions initiated by the Commission, to rule on alleged systemic deficiencies in some member states in terms of judicial independence. For example, because of issues raised in terms of appointment of judges, termination of office of judges, and disciplinary proceedings. Famous examples include infringement proceedings initiated by the Commission against Poland concerning independence of the Supreme Court, or if we focus on references for a preliminary ruling, more recent Romanian cases such as the Eurobox promotion case or the RS case on the disciplinary regime applicable to judges in Romania. Those cases were approached through the prism of rule of law and Article 19 requirements. Another important case to mention, there are many, of course, but another important case is Republica, a case concerning appointment of judges in Malta, which allowed the court to build upon the acquis, if I may say so, of Juízes Portugueses, to establish a so-called non-regression principle. Member states under Article 19, paragraph 1, read in conjunction with Article 2 TEU, are not supposed to reduce the level of judicial independence as that which was applicable at the time they became members of the European Union. That is the non-regression principle. A last illustration, even more recent, are the plenary court judgments of February of 2022 concerning the rule of law conditionality regulation. That judicial cognizability of the rule of law value is absolutely central and even further developed in that in those cases which were decided by the court on actions for annulment by 2 member states, because the court used the lessons of Juízes Portugueses to explain that indeed, since judicial independence and the rule of law is central in the fabric, the constitutional fabric of the EU, it is normal that the Union avails itself with the necessary tools to defend itself against violations of those values by the member states, insofar as such violations have a direct impact on, or risk to have a direct negative impact on EU budgets and the EU financial interests. So we can see that it has had, it has served as a methodological, conceptual basis in many subsequent cases. And I only quote a few here. There are plenty of other examples. Thank you.
Thank you for this very clear explanation. Finally, Mr. Adam, I wanted to ask you the last question. What did it all mean for the Portuguese judges of the Court of Auditors?
As a result of its analysis, the court entered into the merits of the case, if I may say so, interpreted or tried to give as much effective assistance as possible to the Supreme Administrative Court in Portugal, thus assessing the salary reduction measures at issue. The central criterion in independence cases is analyzing, examining whether a given measure is such as to create a reasonable doubt in the spirit of, in the perception of litigants or citizens in general, reasonable doubts as to the imperviousness, ability of a court of judges to decide a case without external influence. That is, to decide a case exclusively based on correct and objective analysis of the facts and the law. And the court came to the conclusion here that the salary reductions at issue did not raise such a reasonable doubt, did not create such a reasonable doubt. In a nutshell, because those salary reductions were limited in scope, were temporary, genuinely temporary limited. They were indeed waived after 2 years. And most importantly, because they were not targeting judges, even judges in general. They were applicable to employees in the public sector in general. So no reasonable doubts, also within the meaning of the Strasbourg case law, could be created in the spirit of on the perception of litigants in that particular case.
Many thanks. And with this conclusion, we are leading towards the end of this podcast. Mr. Radam, thank you very much for a nice discussion we have just had. It was a true pleasure talking to you today. Thank you to everyone. That was the 30 Years, 30 Cases podcast series of ERA.